Hi, my name's Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case City of Chicago v. Fulton. This case was heard in the Supreme Court of the United States in the year 2020. It's worth noting right at the outset, this is not the City of Philadelphia versus Fulton. That was also a case that was heard during this term of the Supreme Court, and it was also a little bit more hotly contested than this one. So this one is about bankruptcy. In this case, we have an issue where we're trying to decide whether the automatic stay precludes a creditor from retaining control over a property after a debtor has filed bankruptcy. All right, so let's put a little bit more color on that statement. So when you file for bankruptcy as a debtor, all of your property under Section 541 of the Bankruptcy Code becomes part of a bankruptcy estate. This automatically happens when you file a bankruptcy petition. Now, someone is tasked with administering that estate, and it's probably not you, especially if you're an individual debtor. If you're a business debtor, it might be, but as an individual debtor, which is what this case was, you are not in control. A trustee is in control of all that property. So that's one automatic thing that happens. All your interests, stocks, bonds, savings, whatever money you might have, though it's probably limited when you file for bankruptcy, comes underneath this umbrella of the estate. Now, second, what automatically happens when you file a bankruptcy petition is an automatic stay goes into effect. The automatic stay precludes any creditors from trying to collect assets from you once you file the bankruptcy petition. So what does this mean? Well, let's say your wages are getting garnished. When you file the bankruptcy petition, the automatic stay will stop that creditor from garnishing your wages. It would also stop a creditor from sending any mail saying, hey, you need to pay us, or calling you and saying you need to pay us. It would stop someone from repossessing your car after you filed that automatic stay. It would stop someone from foreclosing and kicking you out of your home. So it's a very powerful thing, this automatic stay. And the specific language of the automatic stay says it bars any act of a creditor to retain control or exercise control over the debtor's property, right? Okay, so now this case, we have a few debtors. They file for Chapter 13 bankruptcy in the city of Chicago. Now, they don't have their cars when they file for Chapter 13 bankruptcy. The city of Chicago has already impounded them. Chicago is fairly notorious for impounding cars if you don't pay, motor vehicle tickets, traffic tickets, red light tickets, whatever they might be. And so in this case, these debtors have all had their cars impounded. They don't have them in their possession. And they want their cars back. So they think, hey, when I file for bankruptcy, I file that petition. Now the city of Chicago has to give me my car back, and if they don't, they violated the automatic stay. You see, they're retaining control over the debtor's property. And so that is their argument. They say you violated the automatic stay. And it's also important to know that when you violate the automatic stay as a creditor, you might be subject to punitive damages, which could go, high quickly. And so they say we want our property back, and if not, we want punitive damages. They win on that argument in the bankruptcy court. Bankruptcy court says, City of Chicago, you are violating the automatic stay when you are holding on to these cars that are impounded after these debtors have filed for Chapter 13 bankruptcy. The Seventh Circuit Court of Appeals agrees. It goes all the way up there, and they say, yep, same thing. You violated the automatic stay. Now, the Supreme Court reverses. They say that passive control of the debtor's property does not violate the automatic stay. Now, first, they're just going to look at exercise control. The Supreme Court, Justice Alito, and it's worth noting this is a unanimous opinion, but Justice Alito writes for the court, and he says exercising control is an active thing. It's an affirmative act, and just passively holding on to property does not satisfy that affirmative act. He's just a very textual argument, exercise control. When we think of exercising, we might think of running, lifting weights, going for a hike. Those are all active things, and just holding on to something is not active enough to satisfy the exercise control language in the statute. Second, there's a surplusage argument he makes. There's a section in the Bankruptcy Code, 542, right after the Section 541 that creates the estate. And it basically allows for a turnover proceeding, whereas if a creditor possesses property that should be a part of the bankruptcy estate, there's a process called a turnover proceeding where the creditor that's possessing the property and the trustee will basically duke it out, and eventually that property will probably come under the estate, barring maybe some adequate protection. That's a box that really isn't too important for this opinion. But because it exists, the court says, if we were to say that the automatic stay is going to force the city of Chicago to give that property back to the debtors, well, then this section 542 just becomes mere surplusage. And there's a canon that says, we should not read statutes to create surplusage. Everything should be taken in meaning. And because that turnover proceeding created by 542 is expressly created for this type of a thing, where we have a creditor with property and the estate needs that property or wants that property back, if we were to say the automatic stay makes it so the city of Chicago has to give that property back, then this 542 thing just becomes surplusage and irrelevant. So that's kind of the second argument. Now, Justice Sotomayor writes a concurrence, and she notes some very important things in her concurrence. Right off the bat, she says, bankruptcy is about fresh start. I think we all agree with that. Bankruptcy is about fresh start. It's about folks who are in, sad or, terrible financial straits to try and get out of them. And if you don't have a car, how are you supposed to get out of these dire financial straits? Cars are essential in our society today, especially if you live in a suburb, you're trying to get to work. I mean, it's essential. How are we going to let the debtor get back on their feet if they can't have the car? And so that's her big thing, right? She says, well, I still do agree with the court, right? And that's why it's a concurrence, that the automatic stay isn't really meant to, turn that property back over. She disagrees with the Seventh Circuit and the bankruptcy court. But she says, this 542 thing, the court didn't talk about it. This turnover proceeding, it needs to be quicker, okay? We have provided for the statutory method to get this property back over to the debtor, to the trustee, and then to the debtor, because this is a Chapter 13 case. And because we have this, we need to make this effective. She said, practically, we have these cases that are going on for 100 days, and that's just terrible in the sense that these debtors aren't able to get back on their feet quickly. And so she says, okay, sure, I don't say the automatic stay is going to make this happen for these debtors, but we got to make this turnover proceeding more efficient so that these debtors can get back on their feet and the bankruptcy code can fulfill the purpose that it was created to do. And, just thinking about this case, there is kind of a critique where exercising control, it's kind of a narrow textual interpretation by the court. Just for an example, think of a scenario where you lend your bike to a friend and your friend is riding that bike and they're enjoying it, and that was totally consensual. But then after a few weeks, you say, hey, bud, can I have my bike back? But they don't give you the bike back. Are they retaining control? Are they exercising control over the bike by just holding on to it and not giving it back to you? I think that's an interesting and somewhat metaphysical question. And I think that, you probably could have gone another way on that question in specific. But I do find the surplusage argument very persuasive, and I think that was the brunt of the court's argument, where we have a system for this. It might not be efficient, but hey, bankruptcy procedure needs to figure out a way to make it more efficient. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.